False Confessions, the Issues to be Considered, Part 2. What social psychologists, academicians, and defense attorneys say about false confession issues. In anticipation of testifying in a case in which the defense claims the defendant gave a false, coerced confession, it is important to anticipate the type of arguments that may be made to try to establish this point. In the following slides, the statements in yellow are the defense claims. The purpose of an interrogation is to get a confession. In fact, the purpose of an interrogation is to learn the truth, and there are several successful outcomes of an interrogation. Number one, the deceptive person, the guilty person who committed the crime, admits their involvement and gives a corroborated, detailed confession. Number two, the subject maintains their innocence but does acknowledge that they have been lying to us about the fact that they know who did it, and goes on to give us the details as to how they have that knowledge. Number three, the subject maintains they had nothing to do with it but does acknowledge they've been lying about their story, perhaps as to their alibi, where they were, who they were with, because they were embarrassed and didn't want that information to be made public. Or finally, the investigator walks out of the room saying, I don't think this is the guy. I think we better look somewhere else. I think this guy may be okay. Interrogation is a guilt presumptive process. Social psychologists sometimes describe the interrogation as a guilt presumptive process, in that investigators interrogate individuals who they believe are guilty and will stop at nothing to get a confession. It is accurate to say that investigators interrogate individuals that they believe, based on the available investigative evidence, did commit the crime. The alternative would be to interrogate individuals who you do not believe committed the crime, and of course, that would be absurd. Investigators offer the suspect inducements to confess, referred to as minimization, maximization. Social psychologists describe the minimization-maximization process as one in which the investigator suggests inducements that motivate the suspect to confess by minimizing the consequences they will face or the punishment they will receive, by offering them a suggestion or promise of leniency of reduced punishment in exchange for cooperation. And according to the social psychologist, the investigator contrasts the minimization with maximization, in which he threatens or implies more severe treatment if the subject doesn't confess. The problem with this description that the social psychologists refer to is that it describes things that we teach investigators not to do. We never teach investigators to make threats of harm, inevitable consequences, or promises of leniency. There are two types of acceptable minimization that can occur during the interrogation process: minimizing the moral seriousness of the offense and minimizing the psychological consequences of the subject's behavior. The third type of minimization is to minimize the legal consequences, which we teach never to do. There are three errors that lead to false confessions: misclassification, coercion, and contamination. They describe these terms as follows: misclassification, erroneously labeling an innocent person as guilty based on their demeanor and the behavior they displayed during the investigative interview. Coercion, using tactics that offer reduced punishment if the subject confesses, harsher punishment if they do not. Contamination, revealing to the suspect details about the crime that only the police or the guilty person should know. We'll address each of these individually. Regarding misclassification, while evaluating a subject's verbal and nonverbal behaviors during the interview can certainly be helpful in assessing their credibility, in reality, in the majority of cases, the decision to interrogate a suspect is the result of information developed during the investigation. For example, during the interview, a suspect may relate an alibi, and then subsequent investigation proves that the alibi is false. Or the subject claims he never saw the victim at or near the time of the murder, and yet subsequent discovery of video shows the suspect going into the victim's home just moments before she was killed. As for coercion, we teach never to engage in coercive behaviors such as threats or promises or denial of rights. And as for the issue of contamination, we have been teaching for over 50 years to keep the details of the crime secret so you can use the disclosure of those details to corroborate the authenticity of the subject's statement. It cannot be overstated the importance of corroboration to establish the authenticity of a confession. There are two primary types of corroboration, dependent and independent, and these are our terms. And by dependent corroboration, what we mean is that at the outset of an investigation, the lead investigator should decide what evidence or information they have based on the commission of the crime scene photographs, etc. What information, what details do they have that they're going to keep secret? They're not going to release to the media or the public, that they can use to verify any confession. This is called dependent corroboration because the information is dependent upon the crime scene or other investigative source. In theory, only the person guilty of committing the crime should be able to provide to the investigators this dependent corroboration. Independent corroboration. Clearly, the most convincing evidence of a truthful confession is one which contains verifiable information that was not known until the confession. In other words, the police did not know this information. This is called independent corroboration because the investigator does not know the information until the suspect reveals it, and the evidence is obtained independent from the initial investigation. In a murder case, independent evidence would include such things as the tool used to gain entry to the victim's bedroom window, a witness who could place the suspect at or near the scene of the crime, the location of the murder weapon, the location of the bloody clothing, or a souvenir that the offender kept from the victim. Lying to a suspect about evidence causes false confessions. In 1969, the United States Supreme Court ruled in the case of Frazier versus Cupp that misrepresenting evidence to a suspect, in this case the police had falsely told Frazier his accomplice had confessed. So misrepresenting evidence to a suspect is, while relevant, insufficient in our view, in the Supreme Court's view, to make this otherwise voluntary confession inadmissible. These cases must be decided by viewing the totality of circumstances. Numerous court decisions have upheld the investigator's capacity to verbally misrepresent evidence during an interrogation. However, we do urge caution with respect to doing this. For example, from our book, Criminal Interrogation and Confessions, we state that introducing fictitious evidence during an interrogation presents a risk that the guilty suspect may detect the investigator's bluff, resulting in a significant loss of credibility and sincerity. For this reason, we recommend that this tactic of misrepresenting evidence should be considered a last resort effort. We also indicate that this tactic should not be used for suspects who acknowledge that they may have committed the crime but have no specific recollections of doing so. And we also state that this tactic should be avoided when interrogating a youthful suspect with low social maturity or a suspect with a diminished mental capacity. These suspects may not have the fortitude or confidence to challenge this kind of evidence, and depending on the nature of the crime, they may be confused as to their own possible involvement if the police tell them that they have evidence that clearly indicates they committed the act. It should also be noted that misrepresenting evidence in an otherwise proper interrogation does not cause innocent people to confess, but the aggravating circumstances within the interrogation can create an environment conducive to a false statement. Consider the court's opinion in U.S. v. Graham, in which the court pointed out that there have been some cases where statements were elicited from a suspect in response to police deception about evidence that were found involuntary, but in each of these cases, the court pointed out, there were significant aggravating circumstances, such as subjecting the accused to an exhaustively long interrogation, the application of physical force or the threat to do so, or the making of a promise that induced the confession. In other words, it's not the misrepresentation of evidence that is the genesis of a coerced or even false confession, but the aggravating circumstances present during the interrogation. Investigators interrogate children the same way they interrogate adults. Remember, these are going to be defense claims. It is important to note that when questioning juveniles and individuals with significant mental or psychological disabilities, the investigator has to make a number of modifications in their approach. Here are a few of these modifications that we discuss in our courses and our book, Criminal Interrogation and Confessions. Caution must be exercised in evaluating a youthful person's behavioral responses. Due to immaturity and the corresponding lack of values and sense of responsibility, the behavior symptoms displayed by a youthful suspect may be unreliable. It is our general recommendation that a person under the age of 10 should not be subjected to active persuasion techniques, such as theme development or the use of alternative questions. At this age, the child is susceptible to suggestion and motivated to please a person in authority. The interaction between the investigator and the child should be limited to a question and answer session which is focused on factual information and simple logic. When a child is taken into custody and advised of his or her Miranda rights, the question of whether they were capable of making a knowing and voluntary waiver is certainly going to arise. Certainly, a child under the age of 10 is incapable of fully understanding the implications of waiving their Miranda rights. Younger adolescents may also fall into this category. When a juvenile is younger than 15, who has not had any prior experience with the police or law enforcement, is advised of their Miranda rights, the investigator should carefully discuss and talk about the rights with the subject, not just recite them, to make sure that he or she understands them. If attempts to explain the rights are unsuccessful, no questioning should be conducted at that time. The same is true, of course, for a person who is mentally or psychologically disabled. Introducing fictitious evidence should be avoided when questioning a youthful suspect with low social maturity or a suspect with diminished mental capacity. Now we come upon the best practices that investigators should follow so as to minimize the possibility of obtaining a false confession. The best way to avoid obtaining a false confession is to conduct interrogations in accordance with the guidelines established by the courts, number one, and to follow the following core principles and best practices. Do not make any promises of leniency. Do not threaten the subject with physical harm or inevitable consequences. Do not deny the subject any of their rights. Do not deny the subject the opportunity to satisfy their physical needs. Withhold information about the details of the crime from the subject so that if they confess, the disclosure of these details can be used to confirm the authenticity of their statement. Exercise special cautions when questioning juveniles or individuals with mental or psychological impairments. Always treat the subject with dignity and respect. Conduct an interview before any interrogation. Absent a life-saving circumstance, the investigator should conduct a non-accusatory interview before engaging in any interrogation. Conduct an interrogation only when there is a reasonable belief based on the investigative information that this person committed the act under investigation or is withholding relevant information. Attempt to verify the suspect's alibi before conducting an interrogation. When interrogating a non-custodial suspect, do not deprive the suspect of their freedom to leave the room. Do not conduct excessively long interrogations. When a suspect claims to have little or no memory for the time period when the crime was committed, the investigator should not lie about the evidence. Electronically record the interview and the interrogation so there is a record of what was done and said during the entire contact with the subject. And remember that the confession is not the end of the investigation. Following the confession, the investigator should investigate the confession details as given by the subject in an effort to establish the authenticity of their statement, as well as to attempt to establish the suspect's activities before and after the commission of the crime. For additional information on these topics, we have some articles posted on our website, as well as video presentations on our YouTube channel And of course, we discuss all of this in our book, Criminal Interrogation and Confessions. Thank you very much for taking a few minutes to view this presentation.